Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about a case that's been in the news. It's about how very serious charges were stayed because it took 8 years to execute an arrest warrant. This also gives us an opportunity to look at the case of the Queen and Jordan, which is a very critical case if you do any criminal defense work. It's a very important Charter of Rights case. Now, I'm not going to describe the allegations in any detail because YouTube didn't like it when I tried that. I'm going to skirt around things, but I'll link the article so that you can see what they're talking about. So, case collapses after Edmonton police take 8 years to execute arrest warrant. We see the case against Chris Hogan collapsed last month because after he was charged in December 2010 with very serious offenses, it took Edmonton police almost 8 years to execute an arrest warrant. A Supreme Court decision called Jordan sets time limits to ensure an accused's right to a timely trial. In Alberta Provincial Court, the ceiling is 18 months, while in the Court of Queen's Bench, it is 30 months. This is not 100% accurate the way they're describing it. We'll go and have a look at the Jordan case, and you can see what I mean. Had the Hogan case gone to trial, it would have been 120 months, 10 years, from the time he was charged until the conclusion of the case, due primarily to inaction by the police. And the Crown has noted that staying these charges was a very difficult decision, and I'm certain it was. I know people at the Alberta Crown's office. I'm certain nobody came to this decision lightly. I'm sure there was a lot of discussion internally about if there was any way to argue for this case to be saved. They wouldn't have stayed this unless they were certain that this case was basically dead in the water. Now, we see here that there were charges that were originally laid around 2009, 2010, and they're very serious charges. Again, I'm not going to describe the details, but by the time all of this happened and the charges were laid, it looks like the previously accused individual was not in Edmonton anymore. He was now in New Brunswick. And he wasn't apparently hiding out in New Brunswick. They indicate that he was married and living in a small town. He had a Facebook account in his own name. He was sort of living openly. And this is one of the factors that's going to come into play here. I'll explain a little bit more about that. But it took them a while. It was 2018 when he was pulled over by New Brunswick RCMP in a routine traffic stop. And that's why they eventually brought him into custody. And it was looking like it was going to be a while before this would come into court. And so ultimately, we have here in its statement to CBC, the Alberta Crown Prosecution Service said that a prosecution doesn't continue unless the evidence establishes a reasonable likelihood of conviction. They note, in this matter, there is evidence of delay in execution of the warrant that would not survive judicial scrutiny based on the principles in the Queen and Jordan. On this basis, the difficult decision was made to stay these very serious charges. This decision was not taken lightly and was made in consultation with other Crown prosecutors. So as I said, this is a decision that they would have agonized over. There would have been a lot of discussion and meetings and trying to figure out if there was some argument to be made here. And they note that there isn't really a good explanation for why it took them 8 years. Now, the case that governs this, as mentioned, is the case of the Queen and Jordan. But even before you get to the Queen and Jordan, we look at the Charter of Rights because that's what really grounds the Jordan decision. So we have here proceedings in criminal and penal matters, Section 11, any person charged with an offense has the right, and subsection B, to be tried within a reasonable time. So what does a reasonable time mean? Well, prior to the Jordan decision, there was the Morin framework, which required essentially parceling out different bits of delay and ascribing them to defense or to Crown, and also looking at whether there was prejudice to the accused. Now, in the Jordan case, the Supreme Court threw that out. They said this is not a workable framework, and we're going to do something different. In fact, they went in a dramatically different direction. So let's have a look at that. So they note here, the Morin framework for applying Section 11B has given rise to both doctrinal and practical problems, contributing to a culture of delay and complacency towards it. Doctrinally, the Morin framework is too unpredictable, too confusing, and too complex. It has itself become a burden on already overburdened trial courts. From a practical perspective, The modern framework's after-the-fact rationalization of delay does not encourage participants in the justice system to take preventative measures to address inefficient practices and resourcing problems. So this is from the head note. I'm not going to go through the full decision because it's 300 some paragraphs, but the court already is saying things aren't working. There is too much delay in the system. There's too much complacency towards delay. So this is the court essentially calling out the process and saying something has to change. A new framework is therefore required for applying Section 11B. This framework is intended to focus the Section 11B analysis on the issues that matter and encourage all participants in the criminal justice system to cooperate in achieving reasonably prompt justice with a view to fulfilling 11B's important objectives. At the heart of this new framework is a presumptive ceiling beyond which delay, from the charge to the actual or anticipated end of trial, is presumed to be unreasonable, unless exceptional circumstances justify it. The presumptive ceiling is 18 months for cases tried in the provincial court and 30 months for cases in the Superior Court or cases tried in the provincial court after a preliminary inquiry. Delay attributable to or waived by the defense does not count towards the presumptive ceiling. Once the presumptive ceiling is exceeded, the burden is on the Crown to rebut the presumption of unreasonableness on the basis of exceptional circumstances. If the Crown cannot do so, a stay will follow. Exceptional circumstances lie outside the Crown's control in that 1. They are reasonably unforeseen or reasonably unavoidable, and 2. They cannot reasonably be remedied. It is obviously impossible to identify in advance all circumstances that may qualify as exceptional for the purposes of adjudicating a Section 11B application. Ultimately, the determination of whether circumstances are exceptional will depend on the trial judge's good sense and experience. The list is not closed. However, in general, exceptional circumstances will fall under 2 categories: discrete events and particularly complex cases. If the exceptional circumstance relates to a discrete event, such as an illness or unexpected event at trial, the delay reasonably attributable to that event is subtracted from the total delay. If the exceptional circumstances arises from the case's complexity, the delay is reasonable and no further analysis is required. So when they're talking about a discrete event, if that's maybe a witness gets sick and can't make it, or, the accused doesn't show up at trial, although that would probably be delay also attributable to the accused. Something happens that there's a mistrial. I'm sure that there's going to be arguments that COVID-related delays will be a discrete event that causes this. But the court isn't trying to be limited here. They're trying to create a rule that is of general applicability. But they're also going to narrow what can be included in exceptional circumstances. So an exceptional circumstance is the only basis upon which the Crown can discharge its burden to justify delay that exceeds the ceiling. The seriousness or gravity of the offense cannot be relied on. So even in a case like this, where it's very serious charges, that doesn't save things. Nor can chronic institutional delay. And this is specifically because a lot of the decisions prior to the Jordan decision were saying, well, our courts are so backed up that this isn't any sort of special delay. Supreme Court has said, nope, it is your job to unback up the courts. And that actually had an explosive effect. A whole lot of cases were stayed because they'd been kicking around too long. And some cases were stayed in order to make room for other more important cases to get through in time. So most significantly, the absence of prejudice can in no circumstances be used to justify delays after the presumptive ceiling is breached. Once so much time has elapsed, only circumstances that are genuinely outside the Crown's control and ability to remedy may furnish a sufficient excuse for the prolonged delay. Below the presumptive ceiling, however, the burden is on the defense to show that the delay is unreasonable. To do so, the defense must establish that 1, it took meaningful steps that demonstrate a sustained effort to expedite the proceedings, and 2, the case took markedly longer than it reasonably should have. Absent these 2 factors, the Section 11B application must fail. Stays beneath the presumptive ceiling should only be granted in clear cases. So what we see here is the news article described it as sort of a deadline, and once it hits 18 months, that's it. That's not actually how it works. It's that once it hits that 18 months, assuming that it's 18 months that is just solely attributable to the Crown or the general court processes, what happens is the burden of who has to show that there's been an unreasonable delay essentially flips, so that no longer does the defense have to show that there's been an unreasonable delay. Now the Crown has to show that there's been exceptional circumstances that would make it not an unreasonable delay. So that's a big deal, but it tells us that that deadline is not a firm deadline in either direction. There will be situations where a case proceeds past it and the Crown is still able to proceed because of some exceptional circumstances. Similarly, there may be cases that are under that presumptive deadline where the case can be stayed as a result of unreasonable delay, because even though it hasn't hit 18 months or 30 months, there was still some sort of delay. So this becomes a bit of an issue here when we think about the aspect of this individual living sort of an open life where there was no sort of attempt to hide. If we think about, this as compared to somebody who, for instance, fled the country, they were living in Belize, or, they were living perhaps in a very remote part of Canada where they're not going to encounter police, they're hiding out. Maybe they'd taken an assumed name, any of these things. The Crown would be in a much better position to argue exceptional circumstances. But where there's no explanation, as we have here, the Crown's not going to be able to rely on that to establish exceptional circumstances. So they've stayed the case, which means it's over, it's done. He's never going to be convicted. In theory, a stayed charge can be revived. However, in this case, I don't think that's going to happen, because I can't imagine any circumstance where the Crown's case gets better with the passage of time when the problem was the passage of time. So unless something really weird happens, this case is over, which of course is not going to be very satisfying for the complainant on this matter, or for many people in society. Many people are going to see this and say, wait a minute, we wanted to see this trial go forward. Ultimately, a lot of charter litigation is like that, where it's unsatisfying to many people when evidence is excluded from a trial or when charges are stayed. But this is also the only way that charter rights really get defended and protected in our society, which is that charges get thrown out or evidence gets thrown out when they're not respected. If charter rights don't have some teeth, then they end up meaningless. So that's kind of why it's important that charter litigation goes on, even though it's unpopular, even though it's contentious. And people sometimes say, well, why can't we just civilly punish the police for not doing their jobs? Ultimately, that's a very ineffective remedy, and the courts have commented repeatedly on how ineffective that is as a remedy, especially because the courts tend to be reluctant to punish individuals. And who are you going to punish in a case like this? If you say his rights were violated, which officer who didn't take action do we hold accountable for this? So that's why our charter litigation provides other remedies that still may not be satisfying to many people in society, especially those who are close to the case. At any rate, I hope that my explanation has shed a little bit of light as to what's going on in this case and the principles involved. Please like this video, share it with your friends, subscribe to see more, assuming that this was something that you found, interesting or helpful. I'd like to give a special shout out to $50 Patreon supporters, George and D. Moe, $30 Patreon supporter, Steve Browning, as well as all of my $10 Patreon supporters who will be in the crawl immediately following. Thank you. I've got links to the CBC article as well as the Jordan decision in the description below. Thank you once again for watching, and I hope this has armed you with knowledge.